seated. We have two cases on the calendar this afternoon which we intend to take in the order listed. The first case is Ocean Properties versus the Florida Public Service Commission. We've allotted 20 minutes to decide. And before you start, let me say for the benefit of the appellants in both cases, and Mr. Sicking, I know you're familiar with this, but the clock, which I hope you've been enlightened about, when it gets down to the yellow light, that will tell you how much total time you have remaining. It's not how much time you have until you get to your rebuttal time. It's total time remaining. So if you intend to reserve 3 minutes for rebuttal, when you see the clock at 3 minutes, that's your rebuttal right there. Okay.
Thank you, Your Honor, and thank you for that pointer. My name is John Moyle. I'm with the Anchor Smith Grimsley Law Firm, and I'm here today on behalf of Ocean Properties and Dillards department stores. I would like to reserve 5 minutes for rebuttal. The facts are before you and have been brief, but let me just take a minute and indicate that they relate to meters that FPL owned and installed in my clients' businesses and places of operation. It became apparent at some point that these meters were faulty, were over-registering demand, and my clients sought to have monies that they paid refunded to them. They brought the case before the Florida Public Service Commission, and they were indeed awarded some refunds. They were not awarded the amount of refunds that they sought.
There were two different problems with the meters, right?
The primary problem with the meters in question was that they were over-registering demand, and that caused them to bill my customers improperly. And we had expert testimony on that and whatnot. The issues that I wanted to talk about really flow from the meters, but are not that tied to the meters. For example, the three issues on appeal.
Are you abandoning the discovery point?
No. The three issues on appeal are the interest rate issue, whether the judges, the hearing officers, should have recused themselves, and whether it was error for the commission to deny us access to the meters. Let me take the interest point first.
Well, I mean, so some of them there's some kind of thermal aspect?
That's the term as to how the meter operates. It's a thermal demand meter. Yes, sir.
All right, so some of them, there was something, that was what was wrong with most of them.
They over-registered demand, yes. And that resulted in my clients being overcharged.
But something else was wrong with at least one of the meters.
That I believe is correct. And I don't think that's an issue before us today.
All right.
The first issue on appeal is the interest rate issue. My clients were awarded monies back, but the interest rate that was applied was not applied using 68701, which is a statute that the legislature enacted governing interest. That statute says, in all cases where the interest shall accrue without a special contract for the rate thereof, the rate is specified in section 5503. And as most cases with interest go, you have to look at Argonaut Insurance Company. In that case, which said that interest is another element of damages, the Supreme Court of Florida clearly indicated that interest should be awarded, and it stated that interest is something that is set by the legislature. In light of our decision in Argonaut,
but 55.03 has to do with court judgments, right?
It's in the section entitled Judgments, but it is used for other things. For example, just last session, the Florida legislature said in 627-70131 that if an insurance company doesn't pay a claim on a timely basis after 90 days, interest should be paid in addition to that claim, and they use 55 to tell you how to calculate the interest. And that's the same thing that 687.01 does. It says refer to 5503 to determine how the interest should be calculated. There's a case that's directly on point, Kissimmee Utility Authority, which was certified to the Florida Supreme Court. And the question was asked, is a regulated public utility in Florida liable to customers for prejudgment interest on overcharge refunds? The court answered yes, and said...
Since you mentioned the Supreme Court of Florida, maybe we should begin with asking why this case is not within their jurisdiction.
They remanded the case. We filed it originally at the Florida Supreme Court. They determined upon review that it should be properly heard here. So we are here before you today to present our arguments.
So initially you thought it was within their jurisdiction?
Initially we did, yes.
On what basis did you reach that conclusion?
The Constitution indicates that they have exclusive jurisdiction to determine cases related to rates, and we thought that this related to that and filed it at the Florida Supreme Court. You know, they considered it, they had it for a long time, and then referred it back to you. So
the commission didn't ask them to do that?
No.
They did that on their own?
My recollection, it was sua sponte. Anyway, I wanted just to point out that in the Kissimmee case that the Florida Supreme Court did decide, they referenced and said that in light of the Aragonot decision, it's unnecessary for the PSC to refer to prejudgment interest in its rules to assure utility customers are fully compensated in the event of overbilling. And in that case, they squarely said interest should be awarded in accordance with 687.01.
Well, that's only because there was no rule in effect at the time, isn't it?
I would argue not. I would argue that...
Well, there was no rule in effect at the time, was there?
There was a rule that was there, but it did not specifically address this situation.
So they weren't presented with the same factual situation at all.
It was a different factual situation. But, again, I think we don't even have to get there if you consider that the legislature is the entity that sets the interest rate. It's been made clear that that's a legislative decision. It's a policy decision of the legislature, and they have made that policy decision in 687.01.
So your position is that a state agency could never establish an interest rate in a contract under any circumstances?
I would say that what a state agency, in order to do that, would have to have is they would have to have an express delegation from the legislature to do that. And there's no express...
Have you argued here that the PSC does not have an express delegation?
They do not. We do not believe they have the express delegation. We believe it's a matter of statute.
Okay, because I didn't see that in your briefs. I didn't see you arguing, making a 120 argument.
There was a brief reference to it. There actually was a rule challenge that was filed, and the hearing officer said that this is better considered as a 120.57 as applied, that there is some authority to set interest rates to the PSC in interim rate cases, but it didn't appear that there was interest rate authority for refund cases, which we have before you today.
Okay, so you have not challenged Rule 25-6.109 as an invalid exercise of agency rulemaking power.
We challenged the interest rate rule previously, and it was dismissed by...
Did you take an appeal from that?
No. Let me move, given the time considerations, to the second issue, which is a recusal issue. Dillards filed a motion to recuse two of the members of the panel and said that it had a concern that it was going to get a fair hearing before the Public Service Commission. And the basis for its motion was that the Florida Ethics Commission had found probable cause existed that two of the three commissioners...
So this issue only pertains to Dillards and not to Ocean Properties?
Dillards is the one that filed the petition to disqualify or to recuse. So, but the basis for that was that a probable cause finding had been made by the Ethics Commission that two of the commissioners had violated the public trust, had violated an express statute that governed the conduct of the commissioners. And the facts, the Ethics Commission requires that somebody fill out, in effect, a sworn complaint. That was done.
They were both ultimately exonerated, weren't they?
I'm sorry?
They were ultimately exonerated, weren't they?
I believe they were. Ultimately, it was dismissed. There was a change in the statute later on that basically said commissioners could attend events and receive things of value if it was a conference that was held and other people were allowed to attend and things like that. But at the point in time when the petition was filed, the law in the state of Florida is that commissioners could not receive anything of value from regulated utilities that they oversaw. And in this case,
did you allege in your motion to disqualify specifically what it was these commissioners allegedly received?
We did not. We referenced the fact that the probable cause finding had been made by the Ethics Commission. And from a standpoint of they were the ones that went out and did the investigation, they had people looking at it and made that conclusion. We didn't feel that we necessarily needed to go behind and parrot those findings or the facts that they found when they did the investigation.
Did you explain in your motion why Dillards felt they would not get a fair hearing from these commissioners?
I think the motion indicated that it had a concern because it was going in front of a tribunal to have a factual matter decided, that the entity making the determination had been, the two people making the decision had a probable cause finding against them that they had violated the statute that governs the conduct of commissioners. And I think that was the basis for the petition to disqualify. The third point on appeal relates to access to the meters. The meters that were in question were something that was sought by the appellants. Informal discovery and conversations took place with counsel for FPL. Those conversations were had. FPL wrote a letter that said, you need to file a motion to get access to these meters. And 21 days before the discovery deadline, a motion to get access to the meters was indeed filed. That motion was ultimately denied on the grounds that the meters needed to be preserved because they might be subject to additional testing, and that it was pretty close to the proceeding, that it should have been done earlier.
What's the standard of review on this issue?
It's an abuse of discretion. And the Panda Energy case, which sets forth, it's a Florida Supreme Court case, which sets forth that standard of review, I think is telling for this reason. In that case, court said certain findings were not an abuse of discovery, of the discovery discretion vested in the PSC, but in that case, somebody intervened 2 weeks before the hearing, and the commission allowed the intervention, extended the discovery cutoff deadline up until the day before the hearing to allow discovery, and there was an appeal taken of that. In this case, the motion to seek access to the meters...
That doesn't suggest that had the PSC done just the opposite, the Supreme Court wouldn't have affirmed that as well, does it?
It is a discretionary review. I will concede that.
So unless no reasonable person could have reached the result that the hearing officer here reached, or that the commission reached, we have to affirm, right?
I would argue that given the facts of the situation, that the motion to seek access to the meters was 21 days before a discovery cutoff period, that the result reached by the hearing officer was not reasonable. It was a key piece of evidence, the meters in question. FPL proposed a theory that said, we think these meters might have gone bad over time due to deterioration. You could ask an expert at hearing to say, can you tell if deterioration occurred by reviewing the meter? Yes. What would be the result. He could identify what it is, open up the meter, see if it was there. If we had been allowed to do that, I think it would have given us a much better chance of getting refunds beyond a 12-month period of time and getting refunds from the date that the meters were originally
Why didn't you just file a proper motion for inspection before the discovery code?
The way it played out was there was informal discussions. FPL sent a letter to us that said, to my clients, that said, we are not going to allow you to have access to the meters unless you file a motion and obtain it through an order. So for us to then have gone through a process of filing a discovery request, it would have been objected to. We would have had to move to compel. There's law that suggests a futile act is not something that has to be done. So we thought it was appropriate to file the motion at that point in time, again, to obtain access.
When you say at that point in time, how long did you wait after getting their response to file what you did file?
It was over a month. We waited over a month to make that request, to file that motion. So, and the PSC has certain rules. They have pre-filed testimony that's due. We were trying to get it before the pre-filed testimony. It became clear we were not, so we weren't going to be able to use it then.
So at that point, didn't you need to move for an extension of time for filing your pre-filed testimony, as well as taking the next step in getting an order permitting you to inspect the meters?
We could have done that, but we did not. What we did is we filed our pre-filed testimony and figured we would get access to the meters at a later point in time, and then use the access in the meters at hearing. It was, the 12057 factual hearing. We think we should have had the meters in question there at the hearing.
Of course, they ended up being on the hook for the full 12 months. They never sought to establish that the meters had been defective for some shorter period of time, and they had access to the meters. And is there any indication that experts examined the meters on their behalf?
I do not believe that their experts examined the meters on their behalf. I think they just suggested there were a multitude of reasons why it could have gone bad at some point in time. It was our burden to show when it went bad and the cause. We offered a theory that they were bad from when they were installed. They weren't calibrated properly. FPL said we think there was some deterioration. Access to the meters would have allowed you, I think, to see whether our theory was right or whether FPL's theory was right.
Seems to me that would have been the first thing you'd have wanted to do in discovery, is look at the meters.
We took a number of depositions in the case. There were a number of things that we did in it. But I see that my time has almost expired. I have 3 minutes, I guess, remaining for rebuttal. Thank you.
May it please the Court, I'm Richard Bellack, representing the Florida Public Service Commission, and with me at the table is Ken Hoffman, representing Florida Power and Light Company, and Mr. Hoffman is asked to reserve 5 minutes for his argument. Now, the appellant argues that the meaning of the Kissimmee case and all of the statutes involving interest rates are that the Florida Power and Light Company has to accompany its refunds that were ordered by the Commission in this case with a payment of statutory interest. But that's not what any of those authorities say. And in fact, the appellant is not in accord with any of the authorities that they're relying on. What the operable sentence in the Kissimmee case says is, quote, the amount of prejudgment interest to be paid absent a controlling contractual provision has been set by the legislature, unquote. So it could not be more clear that if there is a controlling contractual provision, the amount of interest is controlled by that contractual provision on the authority of the Kissimmee case. What the Florida Supreme Court intended to do was not create an imperial fiat striking down everybody's prearranged interest rate arrangements. In fact, what's indicated is that the statutory rate is a default provision when there is no prearranged interest rate,
Mr. Belloc, is it the commission's position that the Kissimmee utility case decided by the Supreme Court is flawed by false premises?
Well, that's some rhetorical use that the appellant's trying to make of the Kelly Tractor case. If you look at the Kelly Tractor case, there's nothing in Kelly Tractor that is opposed to the Kissimmee case, because it doesn't say that the result of the Kissimmee case was wrong as to the Kissimmee authority. That would be opposed to the Kissimmee analysis. It doesn't say that. What it says is, and I can't account for the rhetoric in the case, the way I read it is that they were unhappy about the way it was being presented by one of the parties in that case, the same way we're unhappy about the rhetorical use being made of it in this case, for the same reason. What they said was the Kissimmee authority decided to rely on a commission rule in their failed argument. They didn't even pick the right rule. So the fact that they lost the argument didn't mean that the Kissimmee case applied in the Kelly Tractor case. That's what they were saying. So it may have been a critique of the way the Kissimmee case was being cited, but we have the same critique. The Kissimmee case says that absent a controlling contractual provision, you use the statutory rate. So it couldn't be more clear that if there's a controlling contractual provision, you don't use the statutory rate. If you look at Section 5503, which is the statutory provision that they're relying on, the last sentence in the statute says, nothing contained herein shall affect a rate of interest established by written contract or obligation. All that we're saying is that Florida Power and Light has an obligation to pay the interest rate set by the commission. And unlike the Kissimmee authority, which didn't want to pay any interest, Florida Power and Light has always stood ready to pay interest at the rate dictated by the Florida Public Service Commission.
Well, even if if the statute applies, it has an exception for contract rates, does it not? Right. And aren't the tariffs, such as the tariffs in this case, aren't they considered contracts?
That's exactly what we're arguing. Under Bell South, it's the contract between the utility and the customer. And what the contract says, what the tariff says, is that billing adjustments for inaccurate meters is made in accordance with the commission's procedures, which would include our interest rate rule.
Now, suppose that the rule challenge we were just told they brought at the Division of Administrative Hearings had been successful from their point of view. Right. By that time, the meters had been changed out, right? So, would it be your view that the rule, despite being invalidated, would nevertheless have been part of a contractual agreement between the parties?
It would have at the operable time period, yes, because unless and until invalidated, it's a valid rule. And it's a valid rule today because they failed at the Division of Administrative Hearings. It was dismissed.
And not appealed, we were informed.
Well, they appealed it. It's on appeal here. And
I misunderstood.
Right. It's in abeyance, as I understand it. It's 1D052981, but that rule has not been invalidated as of this date, and the appeal is in abeyance. But our position is that we had a valid rule.
Now, he said there was some reference in their brief, if I understood correctly, that was intended to raise the question of the rule's validity in this appeal. Is that your reading of the appellant's brief?
Yeah, they still maintain the position that it's invalid, and we maintain the position, no matter what the procedural circumstances, that it's amply valid pursuant to 366.07, which gives us global ability to remedy any kind of situation. And we've got that in our brief.
but just on the basic procedural point, you say that they have raised in this appeal the contention that the rule is invalid.
They mentioned that, and we respond to that in the answer brief. We said it's valid pursuant to at least 3 separate statutes. All 3 of those statutes are mentioned by the administrative law judge in the DOA summary final order, and she didn't find that the rule was invalid.
Well, and don't they have to, aren't there specific procedures for challenging rules as invalid exercises of agency decision-making?
Well, they took advantage of that and challenged it at the decision.
That's not what we're here about today.
No, and they were unsuccessful in that. And in fact, their arguments have always been unsuccessful in all of these areas because they're only in accord with their authority as a matter of rhetoric, not as a matter of analysis. So Kissimmee didn't strike down anybody's obligations or contracted for interest rates, and they're under the obligation to pay interest at the commission rate. And they haven't demonstrated that Kissimmee changes that. Not at all. And none of their...
And Kissimmee was a judicial proceeding, right?
It was a Florida Supreme Court opinion.
But, I mean, it came up from...
It was judicial in origin.
Appeal from a circuit court.
Right, right. And it involved a utility where there was no tariff. There was no commission-approved tariff. There was no analysis that the rule was incorporated into the tariff or the contract, depending on what you call it. And so it's a difference. It's what the Kelly Tractor case says. It's a different set of facts and law. And they've never acknowledged that. They keep coming down to their rhetorical use of these case authorities, and it goes beyond a rhetorical use. It's got to be based on an analysis. And if you take a look at 687.01, which is the statutory rate provision, it says interest rate in the absence of contract. In this case, we're in the presence of a contract. So their authorities demonstrate that our side of the case is correct, not theirs, because of the wording in the authorities that they're citing. And we know there's a contract because Bell South says, the Florida Supreme Court said, the approved tariff is the contract between the utility and its customers. Now, I suppose I should say a few words about the recusal issue, unless there are some more questions about the interest rate issue. As Your Honor pointed out, they very carefully did not tell the court what the complaint was to the Ethics Commission. So the court has no basis from their brief to connect up what they were supposedly so fearful about with the Baybank standard, which is a higher standard for recusal than the judicial recusal standard. There's no way from their briefing that you can look again.
But why should there be a differential standard here where what they're talking about are the very individuals who were scheduled to preside over the hearing, just as a judge would preside in court?
Well, it's based on the idea that agency heads have different responsibilities than judges. It may be that a judicial panel is large enough to allow for a relatively relaxed standard of recusal, but there are only 5 agency heads at the commission. And they wanted, what they were trying to do really had nothing to do with fear. It had to do with the same thing they're trying to do as to the interest rate. The interest rate rule is deemed to be in the public interest according to section 366.01, which deems the commission's regulation is in the public interest. They want the statutory rate of interest because it's a larger amount of interest, but the commission realizes that it's all the customers of FPL have to fund the refund with interest. So the interest rate is set at a different rate based on the public interest. What the recusal thing is about is a strategy to, again, evade the commission's regulation. they wanted to use these probable cause orders as a method of shopping for a different forum so that they could get the case out of the commission's jurisdiction into the Division of Administrative Hearing. So the motions that they filed said, motion to disqualify commissioner and transfer the case to the Division of Administrative Hearing. That's what they were trying to do. And again, it's an argument into the teeth of 366.01. The legislature has deemed it in the public interest for the commission to regulate these companies and to provide a forum for these technical cases.
Well, okay, the motion could have been granted. Two commissioners could have stepped aside, and three would have been left to conduct a hearing.
Well, there were four.
But if I may, just to briefly return to this jurisdictional question. The commission didn't ask that this case be transferred to the first district.
No.
Why not?
Well, I think the original jurisdictional arguments are made by the appellant. And in general, I don't believe in very many cases.
If I understood him correctly, he said they filed there and didn't raise the question.
Right. It had a convoluted history in terms of the jurisdiction, but I believe, my memory is correct, that we took whatever the Florida Supreme Court deemed to be appropriate. We were not actively seeking jurisdiction as to one forum as against another. But we were certainly concerned about the recusal thing because there were 4 commissions that were complained about. And a strategy in the Ethics Commission with the same complaint that was deemed so hyper-technical that the legislature then amended the statute to make sure no one could ever file it again. I mean, it amounted to the theory that a fractional cup of coffee would have been a gift. And so what we were concerned about was that could be a reason to shut down the commission. And we don't think the Topps case provides a reason why you should look at it again, because it's a different level, not only a different level of standard, but very importantly, the statute that deals with recusing agency heads says it's got to be prior to the hearing, not years after the hearing is done. And it would contravene the legislative intent to start that whole process up again. And nothing in Topps speaks to that particular aspect of recusal of agency heads. Thank you.
Okay. You get about 5.5 minutes. You have about 5.5 minutes should you feel you need to use it all.
Thank you, Your Honor. May it please the Court, my name is Ken Hoffman. I'm here on behalf of Florida Power and Light, and I'll address the meter examination issue. That issue actually began with an email in July, on July 2nd of 2004 from the customer's lawyer to FPL's lawyer requesting to examine the meters for use of whatever information they would get in their pre-filed direct testimony. FPL's counsel replied to that 5 days later and said, that's a very ambiguous request. You need to tell us exactly what you want to test for. And keep in mind, we are under an obligation from the Commission to maintain continuous custody and control over these meters. We're obligated to preserve the integrity of these meters in the event the Commission directs us to take further action with respect to that. So what you need to do is you need to take the appropriate action to get Commission approval of any additional testing. Keep in mind, all of these meters, Your Honors, were all tested at least once, some of them twice, and those tests were overseen by the Public Service Commission staff. Once that letter was sent back to the customer's lawyer, they did nothing for close to 50 days, and they waited until after the deadlines for filing the pre-filed direct and pre-filed rebuttal testimony to file this particular motion. The pre-hearing officer took all of these facts into account, including the fact that they waited, some 1.5 to 2 years after they had initially filed their first complaint at the PSC to file this motion. And the pre-hearing officer held, I've looked at all the facts. He told the customers, you failed to take timely action on this issue. You should have addressed this in your pre-filed direct testimony, because if you had done so, then FPL would have had the opportunity to address whatever findings you had made in their pre-filed rebuttal testimony. And that's a pretty important piece, because at the PSC, as we discuss in our briefs,
why was the discovery cutoff set later than the deadlines for pre-filed testimony?
Judge Benton, that's something that is actually typically done. I'm not sure why it's done, but it is done as a matter of practice at the commission. And why it's done, I'm not exactly sure. Those dates are set well in advance. You may have a procedural order issued in February with those dates set 5, 6, 7 months out. But the problem here is that they waited for what they are now calling critical and key information, basically 18 months to ask for it. And it would have given us no opportunity to address it in our rebuttal testimony.
Now, did the inspection that you're telling us about that did take place result in some sort of report?
Yes.
And was there anything in the report that suggested that information about when the meters went bad might be gained by further inspection?
Not at all. The testing that was done tested whether these meters had over-registered and the extent to which they had. Their position all along had been all these meters were initially miscalibrated, but the record showed that half of them weren't. So they had basically come in with a theory that they were all miscalibrated. They asked for these additional tests very late in the game.
You're not conceding that half were miscalibrated when put into service?
No. But we had documentation showing that FPL had never calibrated 6 of these meters in the first place, so they could not have been miscalibrated. So their theory, they had this all or nothing theory, and the record basically, rejected it by showing that half of them were never calibrated in the first place. But they're sort of coming in trying to bail out their lack of diligence here by saying, now we needed it for cross. Well, whatever they would have gotten at cross, it's beyond speculative to try to assume what would have happened on cross, what would have come out on cross, how our witnesses would have reacted to information that was being put at them for the first time. And again, remember, Judge, the reason they're saying now, well after the fact, they wanted this information was to try to show that FPL's defense was not a good defense. It had no relevance to it. It would have done nothing to help them prove up their case. And they admit they had the burden of proof. Nothing to help them prove that these were all miscalibrated at a certain time in the past.
I think you're touching on this, but their argument includes that, okay, this was not going to be included in the pretrial testimony, but we'll deal with it at a hearing, at the final hearing itself. Is that the part you're addressing, that they could only include that in cross-examination? Is that what you're saying?
That's what they're saying. Remember, Judge Polston, they asked for this in July so they could use it in their pre-filed direct testimony. That's why they wanted it, and that made sense. Then they did nothing for about 50 days.
If it's not included in there, they can't put it in their case in chief at the hearing itself. Is that the PSC rules?
That's correct. They have the burden of proof. It was up to them to take whatever findings they might glean and put it in their direct case. When they came back later, when they filed this very late motion to examine the meters, they said, we're seeking to demonstrate entitlement to refunds longer than 12 months. We are entitled to obtain this evidence to meet this burden. The only way they could have met that burden was by putting these findings, whatever they might be, in their direct case, at minimum in their rebuttal case.
Mr. Hoffman, your time has expired.
Thank you, Your Honor.
Mr. Morrell, you have 3 minutes.
Thank you. Let me just go right to that last point. To the extent that we had a theory that the meters were miscalibrated, erroneously calibrated when they went in, FPL's experts said we think it could have gone bad gradually over time. The parts could have worn out. Access to the meters was important to discredit their theory, which would have made our theory more likely. And
that doesn't explain why he waited almost 2 years to ask for it.
Well, the 2-year thing is a little confusing because this was informally filed for a long period of time before it went into a formal process. So I think we got involved in about January of the year. But again, I mean, they would have you look at, well, you should have asked for it earlier. We look at it and say it was 21 days before the discovery cutoff.
Isn't it likely that, in fact, if your request had been granted and you had found anything, the hearing date would have had to have been continued?
I don't necessarily agree with that.
Well, how would they respond to whatever you found without additional time?
Well, if we had it at a point in time that was, 21 days, I mean, the Panda case, they were having depositions taken the day before the hearing started. So I think that, the PSC is a little bit of an unusual creature, but it has ways of, of dealing with those things. Let me just make a point back on the interest. They would have you contend or believe that a tariff is a special contract. There's case law that suggests a special contract is one that you have to have express provisions that are not dependent on implication. And I would draw your attention to the West Palm Beach Limited versus Serpan case. The Jacobs case that they rely on says that a tariff is a contract for carriage. I think as you do the analysis of 68701 and it talks about a special contract, that contemplates people sitting down, bargaining, give and take, negotiations, not a tariff where you file it and then you can use it. Most people on the street, if you say, do you have a contract with your utility, I think would probably suggest that they do not.
But do you accept their point that the rate of interest on refunds affects the utilities costs and therefore what ratepayers generally will have to bear?
Let me answer it this way by saying I think that the way the PSC rule works is it's done on a 30-day T-bill note, which gives you a point in time much closer to a decision. The 687 and 55 goes back and looks at a period of time when you didn't have access to the money. I think the better public policy is that you ought to be compensated for the time you didn't have access to the money, and the legislature has it right. They're the ones that set the policy. I think the idea that the 30-day rate is the one that should govern is not supported by the legislature. It's not good public policy. So for the reasons that we've articulated in our briefs, we would ask that the case be remanded, that the orders be reversed, and that we have a new trial where we can have access to the meters and before an impartial tribunal. Thank you.
Thank you, gentlemen. Next case is